Today we have a new resource person, new professor from Malawi, New Zealand. Let me introduce our colleague, Martin Treadwell, the incoming judge of the New Zealand. Please introduce yourself.
Thank you, Yasu. I'm Martin Treadwell. I am the president of the Asia Pacific chapter of the International Association of Refugee and Migration Judges, and I am the deputy chair of the New Zealand Immigration and Protection Tribunal. I have been making refugee decisions along with my colleague Allan Mackey since the 1990s, and it is a great pleasure to be back in Japan.
Well, thank you very much. Just starting by some any question yesterday's seminar. Any questions? This what comparative studies and Korea and New Zealand. It's kind of a framework. So some of you who haven't studied law, that would be very difficult. No?
The difference between something being de facto and something being de jure is, it simply means in fact or in law. And to talk about someone who is stateless in a de facto sense means that they may not be technically stateless, but they are effectively stateless. For example, they may have a passport or nominally have a nationality, but they can't in fact exercise any of the rights that attach to that nationality. They are in fact, if not in law, stateless. Does that help? It is not clear whether the Rohingya are stateless de facto or de jure. It depends on your point of view. The reality is that whether we agree with them or not, the Myanmar government do not recognize Rohingya as citizens. To that extent, they are stateless de jure. They are stateless by operation of law. We can argue that because they have lived in and most of them were born in Myanmar, that therefore they should be recognized as Myanmar citizens. But there are many countries that don't recognize people born in that country as a national of the country. New Zealand does not recognize as a citizen the child of a couple who may be in New Zealand when the child is born, but neither of them are New Zealand citizens or residents. That child may well be stateless. And so the technical description of whether the Rohingya are stateless as a matter of law or a matter of fact, it depends on your point of view. The Bangladeshi government, which is looking after most of the Rohingya at the moment, they may well say, well, they're stateless de facto, because we still think that they are citizens of Myanmar. The Myanmar government says, nope, they're stateless de jure, because our law does not grant them citizenship. It's very much a point of view.
Yeah, I see what you're grasping about, and I gave you some figures, the higher one being the de facto number, and the de jure 3 million or something or other is more de jure. The 15 million was and you can see the difference, therefore. Yes, I know, and it does have a relevance. I mean, one or two cases, I did some cases in the UK for Rohingya and also in New Zealand. And, well, firstly, you don't get many when they at the appeal level because they're nearly all granted. at the first instance. So that's the reason if you're looking up for a lot of decisions on it, you won't find them because they'll have been approved in first instance. New Zealand and the UK almost the same. That's why you can't find many written decisions about them. That's the reason. However, the particular cases I'm thinking of, both were in the situation where it was clear that from the evidence that the Myanmar government, Burmese government, wouldn't allow these people to return. They had no travel documents, no ability to get back there. And so that situation in itself, the statelessness, almost, when you look through it, depending really on the circumstance, but in one case particularly, that was the basis of the persecution. They had no basis of getting back to where they came from, and they were just permanently rendered stateless. Now, I think we said they were in because of the way they were treated. That was a de jure situation. So but what happened in the UK is by doing that, it then kicked in the UK that they were able to get some sort of status of statelessness. It sounds terrible, but they were able to get some recognition in that situation. So Martin's right, it's very much dependent on the situation. And for example, the tribunals don't actually have jurisdiction in those sort of cases anyway to decide whether to make a judgment on that. So really, they were, even for, because I know the only reason is they came and asked for the citizenship office there, or the immigration or the Home Office came and asked me, well not me, but they asked the court for a copy of our decision so they could then go through the reasoning and then use it in making their own decision on giving this person some sort of status in the UK. So it's complex, very complex.
Yeah, thank you for a very interesting question. In case of the nationalities, this is the two aspects. The state also insists that this nationalities hold or their own discretion or sort of national sovereignty issues who their citizens is. In Japan, mostly the parents, the blood, but some countries, New Zealand or migrant countries, maybe it's where you're born, something like that. So very different policies. But also another aspect is also the source of the human rights itself, because Hannah Arendt discussed this. Of course, he's a victim of the Holocaust of these Jewish peoples. And the case of you mentioned Rohingya is a similar sort of things. If these ethnic groups are actually discriminatory, just deprived of their nationality, that's sort of part of the persecution.
Part of the persecution.
In this sense, kind of conventional refugees.
Yeah.
But we are not so sure how they have such a roots of the Myanmar. But Myanmar is born new country just after the World War II, same as other former colony. So the Bengalese people were here and there in the areas under the British Empire. So when they start nation building, they have to put the line and boundary, something like that. So in such a way, this is a bit controversial and very difficult things. So in this sense, both ways, the Myanmar government just insists it is just illegal migrants from the Bengalese. It's not the original member, something like that. That is why they have a reason to delete their nationality and under their nationality law, something like that. But if it will be abused just for targeting, for cleansing, for ethnic cleansing, this is surely a human rights violation and the reason for the convention refugees. But still, we are all the nations divided into states as the citizens. And interestingly, in the Myanmar refugees, even in Japan, not only the Rohingya, they also lost their nationality because the government just rescind, terminate their nationality after they left Myanmar illegally, according to them. So actually, most of them, almost all of them living in Japan as refugees also not recognized as their citizens as Myanmar. So when they are going back, they have to pay to buy the nationality for reclaiming. And also, very interestingly, here in some border areas in China, many Chinese buying the Myanmar nationality in order to get invest there, because without nationality, you cannot own the land and exploit the natural resources. So, even Cambodia, so many Chinese are buying nationality of their states. So this is very weird to us. But if this is a real policy, or I don't know, this is a policy, or just bribe taking, something like that. So, difficult. So in this sense, the jury and de facto is already such very difficult issues. But it's definitely related with the refugees, because refugees, as he repeatedly mentioned, the surrogate sort of protection, because the refugees are not protected by own state. Stateless people don't have any state to protect. In this world, without any protected by the state, it's very difficult, because the human beings, unfortunately, without the nationalities, no, practically, of course, they have ideally he has a human rights, de jure, but de facto, they are not protected because all the state can refuse to entry to the countries. So how they can survive without any state? Maybe on the boat, drafting on the. That's why the Rohingya was drafted a few years ago, in 200 something in the Andaman Sea, because smugglers just ran away, and some of them were killed and buried in some Thai Malaysia border because they just consider beer. They don't want to get the evidence. So some kind of organized crime people just killed these poor asylum seekers or migrants in the process of the transition. So in this sense, the refugee issues is also kind of in between departure or resettlement. On the way, also that is who will take care of, how to protect. It's also very difficult because international society divided into each state. We don't have any such obligation outside of the state, unfortunately, subject to the international law. So that's why the international law is important, but in Asia, it's not so many signatory countries. So in this sense, they are very much vulnerable in contemporary societies. Okay?
Okay, thank you very much. Right, nice to have you all back, and we're going to pick up where we left off and go on with getting into the actual comparative jurisprudence, looking at a number of Korean cases and Japanese cases in comparison to what we would term as well-recognised international refugee law. As I said yesterday, and I'll say again, this is purely an academic exercise, and there is no way that we would say that this is a professional legal analysis or anything like that, but it has come about through a number of the lawyers and ourselves wanting to make some sort of comparisons, and through a small volunteer army of people who have done translation for us. A number of them are here. Thank you very much again for your efforts, and it's from that we've been able to get a reasonable grasp as what's said in a number of these cases, and from that to do some comparatives. So let's move on. As the concluding part of these courses, we, with the help of the comparative discussions and the recent judgments, we want to look at how they measure up, or how they sit against customary international law. We're going to look at closely about 6 or 7 and 3 Korean examples, and measure them against international norms. As I said at the outset, I want to acknowledge particularly the efforts that have gone in from a number of you and people that have helped us in getting these. And as I said there, we're using, as best we can, of course, just the English translations we have. And that reminded me, as almost every refugee claimant is aware, the comments and conclusions that they reach from it, or the judge or the assessor reaches, is only as good as the translation you have before us. So in some ways we're putting ourselves very much as a refugee would in this plight. So the first comparison I want to make is, and it's probably the most important one from what we've discovered, is that we wanted to clarify what were the actual jurisdictional approaches taken by Japanese judges in cases, appeals or judicial reviews, whatever you call them, at all instances, and also the manner in which the topics are treated by counsel in their submissions. So in other words, we wanted to go through and look closely at them to see what jurisdictional approach was taken. What we found on our own experience was that the Japanese judges' approaches differ quite significantly from what are international norms in this area. Japanese appeals or judicial reviews, whatever you like to call them, they're more accurately, I think, called appeals, on refugee status appear to be treated by the judges more like a domestic immigration appeal. And they are retrospectively, looking backwards, to assess the claims based on the same, or nearly the same, original evidence. That clearly is the impression we get. The judges are thus looking to see if they can create or refuse to create refugee status based partly on their interpretation of the Convention on the Status of Refugees and some of the key elements in it, and their definitions of what is persecution, well-founded fear, etc. Some of these appear to be taken from domestic administrative law used in civil suits, and some of it, to be frank, we have no idea where these conclusions come from. But a lot of them are similar in a number of cases. All right, let's start by internationally looking to see what are the procedural approaches to appeals, judicial reviews around the world. And pretty well every country that we've had experience with, I don't know of any other country, frankly, that does not take one of these 3 approaches in appeals. The first one is what I would call a pure judicial review, where the court seeks to find manifest or material error or errors of law in the first instance or possibly even a second instance decision, and then either upholds the first instance decision as having no errors of law or little, or they're minimal, and either upholds the decision where there's no error, or sends it back, in other words, to the first decision maker with directions on the correct legal approach that should be taken. Usually that's in relation to credibility assessment of the case. That's used very widely across the EU. It's often called the marginal approach in Europe. Countries like Netherlands, Sweden, Denmark, a lot of those countries take purely that approach. The second approach, which is a full, what we call de novo, or a fresh look at the whole case. It's looking forward prospectively from the time it comes before the appeal court or tribunal. And it's the Latin term ex nunc. In other words, you're looking at the evidence forward. The evidence from the first instance can be used because the evidence is usually presented to you, a copy of it and the decision, and that is the way that we do them in New Zealand. And so in fact, the fresh decision is made as at the date of hearing by the judge in New Zealand with all of the evidence, both parties having exactly the same files actually, including all the COI and everything right up to the date of hearing. They're even numbered files, and so you have 300 pages in your file for 300 pages in counsel on both sides. Right, and the third one is a mixture of both, so that this involves firstly a finding of manifest errors or error of law in the first instance or earlier instance decision, and then, if possible, the court will try and rectify the error of law, and in doing that can then finalise the case one way or another. If, however, for example, the same sort of thing, there are problems in credibility assessment, or other witnesses are needed, or other evidence is required that's not immediately available, the case will then be sent back to the previous instance to do the credibility assessment or hear the case again as at the date when it gets back to them, with directions on how that should be done correctly. That's the UK approach. It's a fairly pragmatic one. Because the UK has sort of 3 levels of appeal, that's the one that works at the middle, second instance. Okay, so that means that some cases, I think now in the UK, it's about 50 or 60% of the cases at the upper tribunal level are actually disposed of on the correction of the error of law point, rather than send them back to for the credibility assessment, usually that has to go back and be heard again. Okay, these all 3 recognise what I term, and you've heard me say before, the declaratory point that we discussed in course 1. In other words, refugee status is a process of confirming a status or a reality that you already have when you walk across the border or come into the control, is actually the better term, of a receiving country. Okay, and so it should be carried out fairly and correctly in that method of looking forward, again, prospectively, to the risks on return of being persecuted. So, as I said, a reminder of declaratory or confirmative nature. In Refugee says, is declaratory in nature, and this is the legal term for it, not constitutive. In other words, you're not building up, as you would do in an immigration case, these are the boxes I have to tick. You know, I have to have so many points for this and so much money, and I have to have a degree in so many things, and therefore, like an immigration case, refugees law is not like that. You have the status, and all that happens is the state that's receiving you needs to confirm that status by going through and checking your evidence to see that's correct. As I said, this is very important, and that's why, very importantly, asylum seekers are presumed to be refugees and not sent back once they've made their claim. The legal term, the French term, refugee. Okay, the Japanese decisions, however, comparatively don't appear to take the declaratory point or assess prospectively. They only reassess the historic evidence and risks. Thus, they are actually not making an assessment of future risk in terms of Article 1A2 of the Refugee Convention, and indeed the same article which is in the Immigration Control Act here. Simply put, those decisions are, in our view, of questionable value, particularly if they're dated. For example, if the court does a reassessment effectively of a case that was heard by the, at first instance, say in some of them are, 2012, and the case finally gets to the court in 2018, the evidence they're relying on is 6 years old. And so you're not looking prospectively at all. So the situation could have changed dramatically in either direction. So in fact, it's in those situations, it's not fair to either side. It may be that the state would want to re-look at it, or the claimant. So, and the biggest problem that comes from it in countries where where that's happened, is that it leads to abuse, because people then want to make, well, you've only said this was the situation in 2012. I'm claiming now this is 2019. So, and because a fresh claim is based on a change in circumstances, over 6 or 7 years, quite clearly there's going to be changed circumstances. So the case needs to be reheard. If it's reheard, I don't know quite exactly yet what the Ministry of Justice approach is, but if it comes back to the court again and they still want to go backwards, you're never getting an answer. And so this is the biggest conundrum that we've come across in this. And it is just a recipe for creating abuse in the light of not being able to get finality in their decision.
Aaron, just before you move on to the next point, just check and see if they understand this, because it's an important point.
Yep. Right, let's just stop for a minute. You know, so I'm asking then, why is this happening? And do you know why it happens? Can any of us tell us what? Why the courts take this retrospective look at the cases instead of taking what 1A tells them to do?
Do you all understand the point Alan is making? Because if you don't get this, you won't get the rest of it.
This is really basic to the whole, to all of the work we're doing.
It's perfectly fine for the court to say in 2019 that back in 2012, on the basis of the law and country information then, that the Ministry of Justice got it wrong, and send it back to be done again. And the Ministry will need to do it on the basis of 2019 law, not 2012.
2019 evidence.
Yeah.
Prospectively looking into the future.
But for the court to either say the person's a refugee because back in 2012 they should have been recognised as a refugee on the basis of the facts existing in 2012 is quite wrong. And similarly, the courts should not say, and this is Alan's last point, the courts should not be able to say the Ministry has to go back and assess it on the facts in 2012. You can't do that, because refugee status has to be determined on the facts that exist on the date of determination.
Can you all grasp that?
Does anybody not get it? Put your hands up if you don't get it.
Okay.
Good.
Well, yes. 2019 law. It's a completely fresh look on the basis of the evidence now.
Okay.
Not 20. The other decision is actually irrelevant. And so that in the New Zealand situation where it's a fresh look, the only relevance of the previous decision is for credibility assessment. You said ABC when this case was dealt with in 2018 or whatever it might have been. Now it's come before me and you're saying BCD. So you're saying something different. Please explain to me why that is the case. So you're not bound by the previous decision, but the evidence given in it will contribute towards the credibility or otherwise. All right?
It is possible that there might be difficulty if the country in question has domesticated parts of the Refugee Convention, as, for example, Australia has. In Australian law, the concept of persecution is defined by statute. Now, if that has changed in domestic law between the original hearing and now, you're going to have to work out whether the law allows you to apply the new law or the law that existed at the date of application. And that's going to depend on how it's worded and what the country's approach to the law is. But the Refugee Convention hasn't changed. If what you're applying is effectively international law, there's no change. But it's the same convention we're applying now as existed from 1969 onwards. And so don't get hung up about changes in the law. What is much more important is changes in the facts.
Yeah, we're only giving you what is really international law. The sad thing is that countries like Australia and the US and several others have effectively domesticated part of the Refugee Convention and in their own law, and then that's all they allow their judges and so forth to work in. So it's not international law. They have, really, they should pull out of the convention if you're really thinking of it, but they don't. They want to do it that way. So that's sad, but it happens. So what we're giving you really is the international consensus on it, as is applied pretty much by the UNHCR, who after all do about 28% of the international determinations, and the EU, for example, the directives there are fairly much in line with everything we're telling you. Canada, with some minor exceptions on credibility assessment we won't go into, but and so it's pretty. The Americans is because they've domesticated the whole of international law. So you don't even start. So that it's therefore you can't really use that for precedent value. Although a number of the things about the standard proof and so forth are the same as the rest of the world. Okay, so I'm asking these questions really. Why is it happening? Is it purely as it seems that in Japan domestic administrative law principles are somehow being adopted as they would relate to, as I say, creating purely domestic immigration status, and in so not confirming an international status? So you can think about that and give me an answer the next time we have a break. But if this is so, why are asylum seekers, therefore without valid visas to come into the country, not immediately deported from Japan? If you don't accept it's declaratory, why not kick them out straight away? Why do you let them stay? So in other words, what you've got really, this doesn't happen. And also, just as the same with the world, because refugee claimants are correctly presumed to be refugees during the confirmation process, and thus the non-refoulement and other obligations immediately kick in. So why, in one hand, in Japan, you let them stay here because you're presuming and recognising it's declaratory, but on the other hand, when it comes to the courts, that doesn't happen. It simply does not happen. So, as Martin and I said, it's a mismatch. I don't know the answer, but it just seems odd. And it is not in confirmation, it's not in step with customary international refugee law, or really international, or nearly every form of international or domestic refugee law anywhere else in the world, to be honest, that I know of. And I've probably taught in about 30 or 40 countries, so I haven't struck it before. And it's only by going through these decisions that this has become something that we're now aware of. So, therefore, as I said, from a purely academic comparison, the logic in currently applying international law is set out in the Convention, and the non-refoulements, particularly of the RSAA, but not in the reviews of appeals against negative emojis decisions on RSAA, is to us a little bit of a mystery. But maybe, and we'll look at this decision, which a number of you know about, the Tokyo High Court judgment in what we've decided to call BCD Sri Lanka, a decision from 5 December last year. And the BCD it talks about binding, that the court says the decisions of the court are binding on the MOJ. It says that cessation can only be done by reference to the convention, and we think by assumption from that, it's the declaratory nature of refugee status is also recognised. So this decision, which we'll look at in some more depth later on, is possibly quite a breakthrough. So then I want to look at what might happen in one or two cases, just to get a feel for it. So I looked at this Nagoya case from 2016, Nepali, and it's actually the first case that's referred to on the second sheet. If you want to, I don't know if you've got a copy there, but you can. It's published by the International Law Association in its publication, which curiously is extremely hard to get hold of. But you'd think if they published it, you would make it available. But I think you have to be a law student or something to actually access these decisions. Anyway, so this Nepali, where the reasoning in the law applied, actually to an extent follows customary international law. But there's still a problem. Here the court reassesses all the evidence up to 2011, or in 2011 is probably, and finds, and straight out, he qualifies for refugee status. But the decision, and should be reckoned, but the decision was made in 2016, where the real issue should have been, what, objectively, is his prospective risk of being persecuted on return in September 2016. And to say that he qualifies for refugee status in 2016 on evidence up to 2011, again, is just a mismatch. It just can't be.
What should the court have done, or what could it have done that's different? Yes, but what's the problem with the court trying to do that? What doesn't the court have access to? What can't the court do? The court can't re-interview the man. This is an appeal, judicial review. They're not going to be able to re-interview him and get his up-to-date circumstances from him. Sure, they can look at the country information. What they could have done was to have said the first instance decision was wrong. We're now 5 years on. This needs to be sent back to the Ministry of Justice to do it again on the law and the facts existing today. And they could have re-interviewed.
Yeah, well, the court, possibly if it wanted to, as I said in some of these other jurisdictions, could say, we want the appellant here and to examine them and cross-examine them and so forth before the court. And the court could then, up to that date, prospectively looking forward at the risk on return, including what happens at the airport and what happens when they actually move to back to their own area. You know, you've got to look at the reality of what happens to them, and then make its decision that way. That's the way a prospective decision is done. So in the UK, for example, as I said, if you find an error, you can, if you wanted to, at the upper level, actually call the witnesses in and rehear the case yourself. And that does happen with some complex cases, or where there are lots of law and fact issues to be dealt with. So it's totally capable, or any court's capable of doing it, but it's just really, you need to do it the right way.
It doesn't seem to happen often here, does it?
We'll talk about, as we go through a couple of examples here, you'll see that there's some efforts towards it, probably the best way of saying it. None go the whole way. So that appears very concerning. The judgments in courts, thus, are due to a retrospective approach and don't actually decide whether the person's a refugee at the required date of hearing. They overlook the declaratory point, and the system is really systemically flawed, with major flow-on effects, as I spoke. We look forward to our discussions on this, particularly tomorrow. We look at some of the cases and what happens. And over the years, I also want to look at, before we move on a little bit, international standards in that term. Over the many years, as some of you have spoken, too many years, I've been coming to Japan. I've noted with growing concern that in many decisions, MOJ statements, even academic and media, particularly media articles, say things like the dimensional status of refugees leaves recognition standards up to all the signatories, and or that there are no international standards. And Japan can thus make its own recognition rules without any need to look at international consistency or the Vienna Convention on the Law of Treaties, which tells you that you should do it in the spirit of the convention and give it fair appraisal and fair hearing. So why is that? That they say you can make your own rules. Well, to start with, if everybody did that, why have a convention? You'd have 150 different varieties, and that is just utterly meaningless. If you're doing that, you might as well not bother. So you can see it's the same problem. So with great respect, and I'm not trying to here run down judges or anybody in the system, I'm just saying that before moving on to look at the jurisprudence, I just want to dispel this what appears to be a common or continuing misconception relating to international standards and jurisprudence. In my view, they do exist. There are international standards, and we've been talking about them now, right through the first course and up till now, and they're now firmly part of customary international law. And if you want reciprocity between countries, the better your standard of international interpretation of it, the better reciprocity you'll get. In other words, it's easier to send people back who don't qualify or to work together to get solutions. So that, and as I said, let's note that the status on the refugee and all the other international human rights law we spoke about in the first, the ICCPR and ICESCA and the Children's Convention and all these things, are what's called living instruments. So the interpretation of them will move over time. So the interpretation of the Refugee Convention in 1951 or even 1969 will be very different to what it is today. So in other words, you've got to keep moving with the time. You can't lock it in at the date when you might have signed up or something like that. That's not reality. So let's, just as a simple example, women in certain countries being treated as a particular social group. That simply was not heard of in 1968 or in 1951, but now it's a very common and accepted part of it. The same with cases on sexuality and so forth. Those sort of cases have now become just accepted as totally part of it. FGM cases, all these sorts of things are now something we accept because the law in this area moves on with time. So that's the first thing. So whilst till about 30 years ago, there wasn't much in the way of that you could actually build up. There was the handbook, the UNHCR handbook, which was pretty good. It was written 78, I think it was, 77, by one person. That's why it's coherent. And there were a few academic publications, like very far-sighted material that Graham Madsen wrote in the 60s. And a few, as I said, academic ones. There was little assistance finding international standards, but now, and over the past 25 years, it is an explosion. That's the best way. There is a huge amount of information, whether it be from the UNHCR, EXCOM, that's the Committee of Nations at the UNHCR, guidance, jurisprudence at all levels, which we'll explain in a minute, regional conventions, the OAU we spoke about, the Declaration, the Cartagena, directives, the EU and all its directives, academic and judicial publications, conferences, training, all sorts of things like this have broadened and built up the customary international law. So as I said, it's built up from the highest regional courts, such as in the EU, the Inter-American Court, the Inter-African Court, which meets in Kenya, doesn't it, I think? And then nearly most of the major jurisdictions around the world that are signatories, UK, Germany, France, Sweden, Netherlands, Belgium, I could go on. Even, African countries, South Africa, there's some very good decisions by their highest court, Kenya, Australia, occasionally, New Zealand, Hong Kong, for example, the Hong Kong Final Court of Appeal actually writes some very good decisions. I think the TCAB and others have a bit of difficulty in following them, but that's reality. And then, and even, dare I say it, the IMJ itself. 600 or 700 judges from 70 plus countries, and their work is contributing to the build-up of customary international law. The academic works are really massive. We were going to bring just the ones that were in the library, in the CDR library. They're about this high. Just the ones they happen to have, and you can look in the CDR and see them there. Martin and I stacked them up but decided we didn't need a weightlifting exercise, so, so we left them there. But yeah, that's just to name a few. These are pretty famous names and all this. Hathaway, Goodwin Gill, who we were talking about yesterday. Walter Kalin, Spickerborg from Netherlands, Deborah Anker from the US, Michelle Foster, Jane McAdam, you know, Gilbert, who was going to be here. Stephen Gilbert unfortunately couldn't come. Elspeth Guild, Nick Blake, these are UK ones, Hugo Story, Harold Durig, Costello, what's her first name, an Irish academic who now in Australia. Helen Lambert, a French lady who I think is also in Australia now. Anyway, they've all led to a considerable commonality in the current, what we call IHRL, International Human Rights Law approach to the Convention on the Status of Refugee, particularly on the core concepts of Articles 1A through to F and other customary refugee law. Actually, to be frank with you, when we first started work on the IRMJ in the early 90s, the approach as to whether it should be a strictly international human rights law-based approach was still being debated. And it was really only after about 2 or 3 conferences that we came to the agreement that that's what it is. There is no other way of interpreting it. So, and a lot of that was through academic works assisting that as well. But now this is, 25 years on from there. So the judges' interpretations here, this is the next comparison I want to move on to, which is a very common one. These include persecution, or what it should say is, because the Refugee Convention says being persecuted, it doesn't say persecution. It doesn't say a well-founded fear of persecution, it said a well-founded fear of being persecuted. And we'll talk about that in a minute. But well-founded fear, 4 reasons of and related credibility standards, burden of proof standards, are all things that are very different in the Japanese context to an international one. And as I said, we find them markedly different. If we look at persecution first, in the inclusion clause, as I said, it says, apologies for all the lovely colours, but Martin doesn't like them, but I just, for emphasis, so you can see what it is. So the being persecuted is the part, and also to remind ourselves of the word protection, which is part of the same equation, or part of the equation in being persecuted. It's not just serious harm, it includes a failure of state protection. Almost all the judgments here show the judges reasoning on persecution along the lines as in this Ethiopia 1 case here, which you have, and they say things like, thus it is reasonable to construe that the above-mentioned persecution means assault or oppression, causing sufferings as an ordinary person, whoever he is, cannot endure, which is a deprivation or oppression against life or physical freedom. And that is a fairly common decision in a number of these cases. The concerns here are firstly that there's no sound logic for this statement. I could easily say, it says it here, it is reasonable to construe. I could say it's unreasonable to construe. What's the difference? It's just purely taken out of the ether, that statement. So sorry, I can't see why you would say that, which is made up of the consensus of judges, academics, and so forth from many, many countries. How do you mean? Objecting to what the statements are made in other courts or in academically?
I don't think you should go to customary international law as your starting point for understanding what these things mean, because there is a convention. Why are you going to customary international law? Just because something is broadly accepted at an international level across many countries doesn't make it customary international law. Customary international law is a specific subset of international law. It doesn't require conventions. There are strong arguments that the principle of non-refoulement is an aspect of customary international law. You are best not to get into the language of customary international law when you are dealing with a convention. But your point has validity when you look at, did Japan enter any reservations? To the best of my knowledge, no. What's Japan's explanation for taking a different course to other countries? I don't know. There's no requirement on any country to explain what it does. It's a signatory to the convention. It is subject to reports, as all countries are, by bodies like the Human Rights Committee. And if you want to know what the international view of the position that Japan takes is, look at what people like the Human Rights Committee, which is the supervisory body for the ICCPR and so forth, have a look at what they say. But did Japan enter any reservations? Not that I'm aware of.
No, we'd have to. I should make clear, which I should have at the start, because your point's a good one. There are two parts to it. In other words, there is the actual legal part, which is the convention itself, and so that's why, like I said before, you want to know what being persecuted is. You read Article 1A2. That's it. It's in there. That's real hard black letter law, as we call it. The customary international is the add-on part as to how you interpret things further, and to give more teeth or more understanding in the spirit of it to the actual black letter law itself. So, yeah, that's the two parts to it. Yes. Yeah, it's a very, what you say is, and if this was a really in-depth research project with official translations and everything, we'd have to look into that and go through the XCOM conclusions and so forth to see what had happened. I've been over the years to a couple of XCOM, a long while ago, XCOM meetings, and people speak very frankly at them, that's for sure. So if objections were being made, it wouldn't surprise me that that's where they could have taken place. But I don't know, I'd have to research that. Okay, so coming back to it, first of all, the point I made about being persecuted, and it's important because being persecuted, this means objectively the personal future predicament of the claimant. In other words, it personalises it to somebody with the bundle of characteristics or something about them and what would happen to a person like that on return to their own country. And it's not some generalised state of persecution. And a number of the cases here do talk about I think a Syrian case is a good example, talks about what general persecution is going on. But that's possibly helpful, and that's what COI will talk about. But you've got to bring this back to this person or somebody with this bundle of characteristics going back and assisting their risk, not a risk of generalised persecution. So, and I think a number of them struggle to say the difference between subjective and objective tests. And the reason they're struggling is they haven't actually read the convention and they haven't looked at the terms. I don't know what the Japanese translation of it is, maybe that causes the confusion. But the being persecuted in English leads you directly to make an objective assessment of the future predicament of that person or somebody with their bundle of characteristics. Which is, as you can see the subtle difference between that and just a general state of persecution?
I'm the ordinary person, but nobody else is.
Yeah. We have exactly the same. I was going to come on to that. Who's the ordinary person? I don't know if you know any British law, but there's a famous thing called the man on the Clapham omnibus, which goes way back to the 19th century. And that was some sort of measure they used in tort, not in this sort of law at all. And so what it's got to do with an ordinary person, I have no idea. And so what about an extraordinary person? Or, you know, you just, it's a meaningless, I have to say with great respect, it's a completely meaningless term. If it goes backwards. As an ordinary person can endure. Well, there's no such thing as an ordinary person. People's pain thresholds are totally different. Women can stand 50 times more pain than men can, as every woman who's had a child will tell you. And but no, seriously, so therefore, do you have ordinary women, or do you have ordinary men? Do you have ordinary gay people? Do you have ordinary transsexuals? Where does this end? And so, you know, anyway, let's not go there. I just don't understand it. So, all right, so, and again, there's things like, as I said before, why is it reasonable? I don't know. I think it's unreasonable, personally. And so then it goes on, there's another way, just to take on the comparison a bit further, that the meaning of persecution, not being persecuted again, is supported by reference to the wording of Articles 31 and 33 of the Convention. So let's have a look at these. 31 refers state not imposing penalties for illegal entry. In other words, that's the little gap in the border that if you're a refugee, you're allowed to come in, even though you mightn't have documents or false documents or what have you. And it goes on, where their life or freedom was threatened. And Article 33 said, shall not return a refugee where his life or freedom has been threatened. So why is that a way of clarifying why do you think the judge has said that this is one of his bases for defining refugees? Can you tell me why he uses them? Or what's wrong with using them? How many of you did basic administrative law at university or statutory interpretation? Pretty basic. You cannot define or redefine a definition. It's already been defined. A refugee, you can't be a refugee unless you meet Article 1A2. You can't come along to 31 and say, oh, this is non-refugees. So it's just wrong. It's actually just simply wrong from the point of view of statutory interpretation and the interpretation of conventions. So
Articles 31 and 33 are directed towards people who've already been recognised.
Yes.
It's talking about people who are refugees. So they've already been assessed as refugees under Article 1A2. To grab Articles 31 and 33 and use them to try to, in a reverse engineering way,
Yep.
say what a refugee is perverse.
Yeah, it's highly deceptive, to be quite honest.
Yeah.
And it shows a mindset that is just not fitting to a humanitarian convention, to be quite blunt about it. And so, as I said, comparatively to us, that's a flawed approach, because they refer to refugees, it doesn't say asylum seekers or anybody else, who logically, in the context of the whole convention, have already been defined in 1A2. The judge is thus in error as he or she attempts to redefine a definition. We call that, when I did admin law about 50 years ago, an absolute no-no. If you wanted to fail the exam, give an answer like that.
You can see what Articles 31 and 33 are about. They're about, once the person's been recognised as a refugee, don't penalise them for using a false travel document. And you've got an obligation not to return the refugee to a border where their life or freedom would be threatened. The non-refoulement obligation. Neither article has got anything to do with defining what a refugee is. This is a serious mistake that has been made. And the sad thing is that in these decisions, there is no reference at all to the enormous body of international law that almost universally has reached an understanding of what being persecuted is, which is serious harm arising from breaches of human rights in an absence of state protection. Why this is just ignored in Japanese courts, I do not understand.
It's probably it's the language probably is the main reason behind it, I think, but it's just not translated, or judges don't call for it to be translated. But anyway, as I said, the only meaning of that, life or freedom, in Articles 31 and 30 is clearly just a shorthand reference back to Article 1, the definition clause, and thus 1A2, where refugees are defined within the context of the Convention, as noted in its preamble, is freedom means freedom from being persecuted. It's as simple as that. And from violations, as Martin said, of core human rights, as those set out and referred to in the preamble of the UDHR 1948. It can't be anything else. It's thus universally comparative, as Martin just said, comparatively assessed in this way. So before we move, shall we take a break now for 5 or 10 minutes before we move on to the last of the fairly basic comparisons, and then we might move on to the case studies themselves.
Are there questions about the meaning of being persecuted? What are your thoughts about the view that's taken by the Japanese courts? This language of whether the ordinary person could endure these affronts to their life or freedom.
Do you know where the ordinary... Oh, sorry, go on. Yeah.
No problem with that.
No
problem with that at all.
Yep. I think that's what it must be. That somehow calling it the ordinary person means that it somehow gets objectivity. I can't see that personally, because for the silly examples I was giving a moment ago. But that can only be... And Martin's right. It's an objective test. I said before, the only subjectivity in it is over when they lodge the application. Clearly they have a fear, well, they wouldn't lodge the application, would they? That's the end of the subjectivity. Then, because it's well-founded fear, it's clearly objective. That's why you want all the COI, that's why you've got to get your credibility assessment correct and all these things, because it's an objective assessment. And, the ordinary person may be just a reason for bringing that in. I don't know.
But to limit the meaning of being persecuted to risks to your life or freedom is just completely inadequate. The ability of man, and I use the word man deliberately because most persecution is caused by men, the ability of man to dream up new reasons to hurt other people is limited only by the human imagination. We are an extremely successful animal at harming other people. And to limit serious harm to just attacks on life or freedom is very dangerous. If your government passed a law that says, because of your race or your political opinion or your religion, you were never to be allowed to work again in your life, acceptable? How are you going to support yourself? It's not an attack on your life or your freedom. If you're never to be allowed to work again, I suspect most people in this room, really and truly put in that position, they would feel that they were being persecuted, that they were suffering serious harm, that arose from a breach of their human rights. This is why you can't limit it to physical harm. There are so many ways that people are capable of seriously hurting other people.
Even in one of those Ethiopia decisions, because and this is where this woman, it's agreed that she was raped at some stage, but the conclusions on that are virtually saying because it wasn't a threat to her life, it isn't persecution. I find that just abhorrent. But that if you read that decision, that's the conclusion you can reach. And I just don't know how a judge could ever come to that conclusion. So anyway, I'm being a little bit blunt, but that's the reality of it, as we see it on the translations we've got. All right, let's take a break and we'll come back.